Professor Talmon.
Madam President, distinguished members of the Court, it is an honor to appear once again before you and to do so on behalf of the Republic of Turkey. This is the first time that issues concerning the use of bylog arise before this Court in the context of Article 6 of the Convention, rather than Article 5. In this case, the question is whether the applicant received a fair trial, not whether there was a reasonable suspicion of him having committed an offense. The Court's earlier bylog case law under Article 5, therefore, can be distinguished both on the facts and the law. The central issue under Article 6, paragraph 1, the requirement of a fair hearing, concerns the domestic court's assessment of the evidence and its finding that the applicant used bylog, and that this use of bylog, together with other evidence, established his membership of an armed terrorist organization. It is well established that the Court has no jurisdiction to substitute its own findings of fact or law for those of the domestic courts, which are in the best position to assess the evidence before them and apply the relevant domestic law. This Court is not a fourth instance body. In Ocak versus Ukraine number 2, the Grand Chamber held that Article 6, paragraph 1 lays down no rules on the admissibility of evidence or the way in which evidence should be assessed, these being primarily matters for regulation by national law and the national courts. Normally, issues such as the weight attached to a particular item of evidence or assessments submitted to the national courts for consideration are not for the Court to review. Only decisions that are arbitrary or manifestly unreasonable may be found incompatible with the guarantees of a fair hearing. The threshold for a finding of arbitrariness or manifest unreasonableness is very high indeed. The Court has required a manifest error of assessment, that is to say, an error that no reasonable court could ever have made. The unreasonableness must be striking and palpable on the face of it. A domestic judicial decision cannot be qualified as arbitrary to the point of prejudicing the fairness of the proceedings unless no reasons are provided for it. If the reasons given are based on a manifest factual or legal error, if the reasoning disregards the bulk of the evidence presented, or if the decision fails to connect the established facts, the applicable law, and the outcome of the proceedings. None of these requirements are met in the present case. The inferences made by the domestic courts were not manifestly unreasonable or arbitrary. There are no objective reasons to call into question the assessment made by the domestic courts. Indeed, the trial court's assessment was shared by all other Turkish courts assessing the evidentiary value of the use of bylaw, including the Constitutional Court. In Ferhat Kara, the Constitutional Court held that the applicant's conviction for his membership of a terrorist organization based solely on the use of an encrypted communication network cannot be considered a manifestly arbitrary practice. Can it seriously be argued that all Turkish courts acted unreasonably? This court itself, in Akgün versus Turkey, held, and I quote, "The use of electronic evidence indicating that an individual availed himself of an encrypting messaging service which had been specifically designed for and exclusively used by a criminal organization for the purposes of that organization's internal communication could provide a strong indication that that individual belonged to such an organization." End of quote. The court thus accepted in principle that inferences with regard to membership of a criminal organization may be drawn from the use of an encrypted messaging service that was exclusively used by the organization. Both the Kayseri Second Assize Court and the Ankara Regional Court of Appeal expressly found, after a detailed examination of the electronic, technical, and other evidence, including expert reports and confessions by FETÖ members, that bylaw was used exclusively by members of FETÖ with a view of ensuring secret communications within that organization. In addition, the Ankara Regional Court of Appeal expressly relied upon the decision of the 16th Criminal Chamber of the Court of Cassation in the case of Baja and Öcalan, which had only been given 5 months before. This 201-page long, extremely thorough decision, which was confirmed by the plenary session of the Court of Cassation, Turkey's highest court in criminal matters, established after lengthy examination of the evidence that bylaw was used exclusively by members of FETÖ. The Court of Cassation also explained in detail the evidential value of the use of bylaw for proving membership of a criminal organization. In Akgün versus Turkey, this court said that where electronic evidence such as bylaw data is used as the sole basis for establishing membership of a criminal organization, the national court has to have available sufficient information about the material in question before examining its potential evidential value under domestic law. The extensive expositions on bylaw clearly show that the trial courts had sufficient information about the material. In any case, the use of bylaw was not the sole basis for establishing the applicant's membership of FETÖ. The trial courts also took into account that he was a member of associations and trade unions connected with FETÖ, and that he provided financial support to a bank affiliated with FETÖ in response to calls made by the leader of the organization for the recovery of the bank. Madam President, the court's task is to assess whether the proceedings as a whole, including the way in which evidence was taken, was fair. In particular, the applicant must have been given the opportunity to challenge the authenticity of the evidence and to oppose its use, and his defense submissions must have been properly examined by the courts. In addition, the quality of the evidence must have been taken into consideration, including whether the circumstances in which it was obtained cast any doubt on its reliability or accuracy. In adversarial proceedings, in which the applicant was fully involved and legally represented, he availed himself of the opportunity to challenge the bylog evidence and oppose its use. He called into question the authenticity of the bylog data, did not accept the various reports based on that data, and requested a fresh report. It is, however, a matter for the trial courts to assess the authenticity and evidentiary value of evidence, including electronic data and expert reports. As stated by this court in Ayatollah A versus Turkey, the mere fact that the trial court relied on the opinion of a particular expert does not reveal any unfairness. The court also held in PW versus Austria that Article 6, paragraph 1 does not impose on the trial court an obligation to order an expert opinion or any other investigative measure merely because a party has requested it. Thus, the Kayseri'de Assize Court rejected with reasons the applicant's request to submit the bylog data pertaining to him into the case file. And the Ankara Regional Court rejected the request for another report on the bylog data. The applicant also put forward the argument that the bylog evidence could not be used because the bylog data had been obtained illegally, including in breach of the right to respect for private life. Both the Kayseri'de Assize Court and the Ankara Regional Court of Appeal rejected this argument after establishing the legality of the acquisition and use of the bylog evidence. The legality of obtaining the bylog evidence was also confirmed by the Court of Cassation. In addition, the Ankara Regional Court of Appeal expressly addressed the question of the quality of electronic evidence such as the bylog data. Madam President, as to the applicant's claim that he was not tried by an independent and impartial tribunal established by law, this has already been dealt with by this court before. In Baja and Öcalik versus Türkiye, the court held that the decision of the High Council of Judges and Prosecutors that the second assize courts could specialize in dealing with terrorist offenses was in accordance with Article 6. The applicant has failed to substantiate his claim that the judges of the second Kayseri'de Assize Court or any other judges seized with his case lacked impartiality. As in the case of Bash versus Turkey, the applicant's submissions amount to criticism of the judiciary in general and do not concern the judges involved in his case specifically. These judges enjoyed the same constitutional and legislative guarantees ensuring their independence and impartiality as all other judges. Moreover, there is no indication of any prejudice or bias on the part of the judges as regards the applicant's personal circumstances. This complaint should therefore be rejected as being manifestly ill-founded. In conclusion, no unfairness resulted from the use and assessment of the bylog evidence. There is also no basis for the claim that the applicant was not tried by an independent and impartial tribunal established by law. The applicant's claim with regard to Article 6 should therefore be dismissed. I thank the Court for your careful attention. Madam President, may I now please ask you to call on Dr. Staker to address you on the issues arising under Article 7, 8, and 11.